All right, it's case number 22-116, State of Ohio versus Justin Conley. Are you Justin Conley appearing there from CCI? Okay, I cannot hear you.
Yes, Your Honor.
Okay, there you go. All right. You need to just lean up a little closer to the microphone. All right, this is a hearing on a motion for judicial release filed by Mr. Conley's attorney, Jacob Wagner, who is present in the courtroom. Also present on behalf of the state is Assistant Prosecuting Attorney Adam King, and Mr. Conley is appearing by video from CCI. The defendant was sentenced on August the 3rd, 2022 to a term of 48 months and filed a motion for judicial release. The court has ordered a post-sentencing report. I have received that. All right, Mr. Wagner, anything you would like to say on behalf of your client?
Yes, sir, Your Honor. Again, this has obviously been roughly 9 or so months ago, but if my memory serves me correctly, I guess that's part of the investigation. This is one of those ones we get every once in a while where you're actually pulling the guy. I think he had a lot of support with the surgeon in our office. One of those cases where a gentleman had committed the act quite some time ago, got clean, was going great, and you just kind of hate to see him go back to prison, go to prison. This is one of the guys that I remember, Your Honor, just again, not to sound corny, you just feel for him. You think he's going to do the right thing, he always says the right things. I just ask the court to read the motion.
All right. Mr. King, anything on behalf of the state?
The state has no objection to the motion, Your Honor.
All right. Mr. Conley, anything you would like to say on your own behalf?
I would just like to have a chance to get it out and just do what I'm supposed to do. Make my mom proud of me. Make my family proud.
All right. Well, it's the order of the court that your motion be granted, Mr. Conley. It'll be effective on August the 1st because you're going to be going to the STAR program on August the 2nd. So effective August the 1st, you'll be released from the custody of the sheriff, brought back to Highland County and held until you're conveyed to STAR. The conditions of your release and supervision under community control are as follows. It'll be for a period of 3 years. You'll be required to obey all laws of all jurisdictions, conduct yourself in a law-abiding manner at all times, and be truthful in all statements you make to the probation department. You must report when and as directed. You must keep them informed of your residence and place of employment at all times, and it may not change either without prior approval. You may not leave the state of Ohio at any time without prior written permission of your supervising officer. You may not enter upon the grounds of any correctional facility, nor may you communicate with or attempt to communicate with anyone who's an inmate in those facilities without prior written permission. You're not permitted, because of your convictions, to purchase, possess, use, or own or have under your control any firearm, ammunition, or dangerous ordnance, and that's a condition of the supervision, as well as not permitted to have any other weapons of any type. You may not purchase, possess, use, or have under your control any alcoholic beverage or any controlled substance or drug of abuse, or any instrument, device, or thing may be used to administer drugs, prepare their administration or use unless you have a lawful prescription, copy of which must be provided within 24 hours of receipt. You're not to be present in places where alcohol is being sold or consumed if it's otherwise lawful. You must submit to drug testing when and as directed. You may not associate with any person who is a co-defendant in this case, or any person who is a member of a gang or other criminal group, or any other person who has in the past or could in the future influence you to commit a violation of these conditions or a criminal offense. You're not permitted to marry or establish cohabitation under the common law marriage type of a relationship with another without prior permission in writing. You must report any contact with law enforcement or any arrest, citation, conviction, or other charge of violating the law not later than the next business day after that occurs. You must provide your supervising officer with financial information records so your ability to pay any fees or costs can be reviewed. If probation refers you for any other evaluation assessment for any type of treatment or programming beyond that ordered by the court, you'll submit to that. If there's a recommendation for programming you are to enroll in and successfully complete that. You'll be required to pay the court costs and make payment arrangements to do that. You'll be required to make restitution in the amount of $482.94 jointly and severally with your co-defendant to Highland County Task Force. And you'll be required to successfully complete the STAR program and any recommended aftercare. And you'll remain in jail until that time. There is a bed available for you on August the 2nd. Now, by being released on community control, you're deemed to have consented to a search without a warrant of your person, residence, vehicles owned by you, used by you, or any other property or place where you're found or that's under your control at any time by any officer of the probation department. Now, in the event that you fail to comply with these conditions, probation will file a written notice of that with the court. There will be a hearing. You'll be entitled to have an attorney. If the outcome of the hearing is that you have failed to comply, then you'll be returned to prison to serve the balance of your sentence. And I'll also tell you, Mr. Conley, that the requirement to complete the STAR program is absolute. There's no partial effort. So you don't get any credit for 80%, 90%, or even 99%. You must complete it successfully. If you don't, then you'll be going back to prison. All right, you understand that?
Yes, Your Honor.
All right, anything further from counsel?
No, sir.
All right, the sheriff will be there to pick you up on the 1st, and you'll be taking a STAR on the 2nd. All right, thank you. This is case number 23 CR 49, State of Ohio versus Kendra D. Ward. Present for the state's Assistant Prosecuting Attorney King, President Defense Attorney Kathy Hafner, and you are Kendra D. Ward.
Yes, sir.
All right, Ms. Ward has entered a plea of guilty to failure to comply with the order of signal police officer, a third-degree felony. Matter was referred for the probation to do a pre-sentence report, which I have received. Have each of the attorneys reviewed a summary?
State has, Your Honor.
I have, Your Honor.
All right, anything from the state regarding sentencing?
Only was contained in the plea agreement, Your Honor.
Ms. Hafner?
Thank you, Your Honor. We would ask that you follow the plea agreement. Ms. Ward is down at Another Chance Ministries. She's been there since, I think, since about mid-April. My understanding is that she's going through the program and there are not any issues there. So we would ask that you grant her community control that, subject to completing her residential treatment and then whatever follow-up and aftercare is needed.
All right, Ms. Ward, is there anything you'd like to say?
No, Your Honor.
All right. It's the judgment order of the court that you be sentenced to a term of 3 years of community control under the supervision of the probation department under the following conditions. First, you obey all laws of all jurisdictions, conduct yourself in a law-abiding manner at all times, must report when and as directed, must be truthful in all statements you make, as well as all answers you give to questions that are asked of you by the probation department. Must keep them informed of your residence, place of employment at all times, may not change either without prior permission. Do not leave the state of Ohio at any time without prior written permission. You may not enter upon the grounds of any correctional facility, nor may you communicate with or attempt to communicate with anyone who's an inmate in any of those facilities without prior written permission from your supervising officer. You're not permitted to purchase, possess, own, use, or have under control any kind of firearm, ammunition, dangerous ordnance, weapon of any other type. You may not purchase, possess, use, or have under your control any type of a controlled substance, drug of abuse, CBD oil, kratom, or any variant or analog of any controlled substance that has an effect similar to controlled substances or drugs of abuse, or any instrument, device, or thing may be used to administer drugs or prepare them for administration or use unless you have a lawful prescription. You must provide a copy of that within 24 hours of the receipt. You must submit to drug testing when and as requested. You may not purchase, possess, use, or have under your control any kind of alcoholic beverage, nor may be present places where it's sold or being consumed unless otherwise lawful. You may not associate with any person that has a criminal record as a member of a gang or other criminal group, or any person who has in the past could in the future influence you to commit a criminal offense to violate these conditions, unless approved in writing by your supervising officer. That applies to any family members that fall within that definition, unless you're living with them immediately before the commission of this offense. You may not marry or establish cohabitation in a common law marriage type relationship after this date with another person without written permission. You must report any contact with law enforcement on any arrest, citation, or conviction or other charge of violating the law not later than the next business day after that occurs. You must provide your supervising officer with financial information records so your ability to pay any fees or costs can be reviewed. If you're referred for an evaluation assessment for further programming, treatment, counseling, etc., you'll submit to that. If there's a recommendation that you undergo that type of programming, then you will enroll in and successfully complete it. Pay the court costs of this action and make payment arrangements to do that with the clerk's office. You'll be required to successfully complete the ACM residential treatment and any recommended aftercare. Now, by being placed on community control rather than being sentenced to prison, you're deemed to consented to a search without a warrant of your person, residence, vehicles owned by you or used by you, or any other property placed that's under your control where you're found at any time. Any officer of the probation department, you'll be required to sign an acknowledgement and consent of that. There'll be no fine imposed. The court for at least 3 years, could be up to lifetime. It's the order of the court. Your suspension be 3 years, commencing July 20th, 2023. The court will consider granting limited driving privileges permitted by law upon proof of financial responsibility and that you're otherwise legal to drive. Now, you're also ordered to pay the court costs and make payment arrangements to do that.
Yeah.
And if you fail to do that, the clerk can collect that through various means, including levying on bank accounts, wages, earnings, or other assets you may have, referring it to collections, which could result in an additional 30% surcharge for the collection agency. If that's not sufficient to collect it, then the court could order you to do community service and give you credit for each hour you worked in an hourly rate set by the court. Each hour you work would reduce your judgment by that amount until paid in full. Now, in the event that it's the probation department feels that you have failed to comply with these conditions, they'll file a written notice up with the court. There will be a hearing. You'll be entitled to have an attorney to represent you. The outcome of that hearing is that you have failed to comply. At that time, the court could revoke your community control and sentence you to a prison term of between 9 and 36 months in the increments provided by law and a fine of $10,000. If that occurs, upon completion of the prison term imposed by the court, it is mandatory that you be under post-release control supervision under conditions set by the Adult Parole Authority for a period of at least at least 1 year, not more than 3 years. And if that occurs and they find that you have failed to comply, they can return you to prison and make you serve an additional period beyond that ordered by the court of up to 9 months for a single violation, up to a maximum of half of your prison term for all violations. However, if you committed a felony, in addition to whatever sentence the judge in a new case could impose upon you, that judge is also authorized to sentence you, in this case, to an additional period of 1 year, or whatever time is left on that period of post-release control, whichever is greater. If that occurs, that has to be served consecutively to the sentence in the new case. All right, is there anything further from counsel?
No, Your Honor.
All right, then you are now off of pretrial supervision, but you'll need to report to the probation department to let them know that you're now on regular probation.
Okay, thank you.
All right, thank you. All right.
Your,
All right, this is case number 23 CR 005, State of Ohio versus Jeremy E. Hogsett. You're Jeremy E. Hogsett, appearing from the jail.
Yes, Your Honor.
All right, this is a hearing on bond and status on Mr. Hogsett. His attorney is Catherine Hapner, who's present in the courtroom, and present representing the state's Assistant Prosecutor Adam King. The court issued a warrant for Mr. Hogsett's arrest due to the fact that he was not complying with the conditions of his pretrial supervision, ordering him to report as directed, and also the probation department informed the court in a notice that was filed on July the 12th that he had 2 warrants out for him from probation or from the municipal court. And I believe that at one point Ms. Hapner indicated she had not been able to communicate with him, and therefore the court issued the warrant and vacated the trial date due to the uncertainty as to whether he would be present, and we needed to send out jury notices, so we did not. So Mr. Hogsett is now before the court pursuant to the Capias. Now, Mr. King, was the alleged victim of this offense notified of the hearing and the purpose and so forth?
Yes, sir, Your Honor. They've been notified and are not present.
All right. Okay. Ms. Hatner, I'm going to address the issue of bond first.
Yeah, I did speak with my client at the jail this morning, and he indicated to me that he had moved and didn't, I think the notice to him was not forwarded on to him, he did not get it. I've explained the importance of keeping in touch with both the probation department, the court, and myself, and he's indicated to me that he does understand that, so we would ask that his bond be reinstated.
All right, Mr. King?
Thank you, Your Honor. The state would request that the defendant's OR bond be revoked and that a bond be set in this matter. Would note the obvious fact that the defendant failed to appear at the last hearing back on July 12th. Nobody, it's my understanding, the probation department, Ms. Hatner, nobody was able to get in touch with him to tell him he needed to be in court. Then it came up during the hearing from the pretrial supervision officer that the defendant had not been reporting to probation and that he'd also accumulated 2 active warrants out of Hillsborough Municipal Court. So based upon that, the state would ask that a bond be set in this case. Thank you.
All right. Well, I'm not going to release you on your own recognizance, Mr. Hogsett. Number one, that excuse that you gave is really lame. You were told to report to probation. You weren't doing it. If you've been reporting, you would have known it. I can't imagine that you moved and didn't leave the forwarding address. If you didn't, that's on you. If you did, then I don't believe your story that the notice wasn't forwarded, because the post office forwarded mail all the time. And the other fact, the fact that you're not reporting and have been non-compliant with pretrial supervision makes the court feel that there needs to be a bond. So it's order of the court that your bond be set in the amount of $5,000 plus your own recognizance, which is your promise to appear. If you fail to appear, you could be prosecuted for an additional felony and if convicted, sentenced on that, no matter what happens in this case. You'll also be required to pay a deposit of $171 prior to release. If you make bond, you report immediately upon release to the probation department, and then after that is a direct. You also are to, if you were released, contact your attorney to make an appointment to discuss this matter. Now, this case has been dragging on, and I granted a continuance I didn't want to grant, and then this has happened, and we had to vacate another trial date. And so I'm going to get a firm trial date when it's going to happen. We're done dilly-dallying with this case. So, Ms. Hatner, you have your calendar there?
I do, yes.
What was the case that we're going to do a plea on next week?
Timothy Williams.
When was that set for trial? We just had that pre-trial, I think, yesterday, wasn't it? And I was just looking for that date because I knew you were available that day.
Well, I wasn't actually available, but
Timothy Williams is currently set for August 7th, Your Honor.
yeah.
Okay, if it's not that date, because I've already said we were going to continue it. We continued it from that date, I thought.
I think we did because I think that, but I'm, oh, it was set for September 14th.
September?
September 14th.
Yeah, I don't want this one to go out that long. Yeah.
And he doesn't have that to September 14th. He just said that. Why is that just got sent to me as a Zoom?
About the 28th.
Of August. That's my regular day in Fayette County.
All right, then the 29th.
Yep, that works for me.
All right, we'll do the 29th and 30th. This is going to be a 2-day trial.
Probably.
All right, 29th and 30th at 8 a.m. And then a final pretrial we'll set for August. Let's see, I think the regular pretrial is the 16th. It's 13 days prior. Yeah, 16th at 1 o'clock. All right. Anything further from council?
No, Your Honor.
All right, thank you.
Thank you, Your Honor.
All right, this is case number 23 CR 50, State of Ohio versus John Henry Jennings. Appearing on behalf of the State's Prosecutor Collins, Assistant Prosecutor King. Appearing on behalf of the defendant is Attorney Jacob Wagner. Appearing on behalf of the State's Prosecutor's Office. And you are John Henry Jennings.
Yes, I am.
All right, Mr. Jennings has entered a plea of guilty to theft from a person protected class, a 4-3 felony, and unauthorized use of a motor vehicle, 5th-degree felony. The court referred the matter for a pre-sentence report, and I have reviewed that. Of each of the attorneys an opportunity to review a summary.
State has, Your Honor.
We have as well, sir.
All right, Mr. King, on behalf of the state.
Thank you, Your Honor. Per the terms of the plea agreement in this case, the state has agreed to take no position as to sentencing. I would note for the record that the victim in this case, Norman Carmine, is present in the courtroom today. Just to make the court aware of his position, he has indicated that he feels a term of incarceration is appropriate. Mr. Carmine does not wish to make any statement today. And the restitution in this case is $940 to Norman Carmine, and that is agreed upon in the plea agreement. That's all, Your Honor.
Well, she's deceased, isn't she?
That would be, Norman's wife is deceased, but Norman's present.
Oh, okay, no, I thought, okay, it's payable to him, not to his wife, okay. All right. Mr. Wagner?
Your Honor, throughout this case, John and I had a multitude or multiple discussions and issues around the case and sentencing and plea negotiations. And we were able to negotiate this where the state would take no position. Obviously, we're making a strong push, Your Honor, for your drug court. And I totally understand. I told John we had a battle here. Of course, when we look at the PSI, see his past history, you're probably well aware of John. He's been to prison twice, and I know that's a strike against me. Why would this court ever grant a guy drug court that's been to prison twice? Your Honor, my position on this is exactly why this court established drug court and many courts around this state. John is 53 years old, and I mean this respectfully to him. He's a drug addict. I've got to know John, he calls me about weekly, but he's going to battle drug addiction for his entire life. If you look at all of his crimes, and I didn't handle the other ones, but I know this is why this, in my position, this crime was committed. It's sadly enough, and this maybe cuts against me, he stole from his deceased mother. Now, she wasn't deceased at that point in time, but he'll have to live with that for the rest of his life. I mean, what a burden to carry. He was cashing her checks to fuel his drug habit. Since then, though, John reached out to Ms. Sturgill. He got himself into counseling. I noticed today he does have, I say his coins, or however you want to say it. He's been clean for 6 months. He went to the counseling center.
Just a second. All right, go ahead.
Yes, sir. And I do have a copy of a letter if the court wants it. It's only a small paragraph from the director of services or the service provider at the counseling center outlining what great things John has done. Basically, with his checking in there, he's done the AOD, individual group counseling, case management, individual sessions, 12-step self-help groups, as well as participating in random urine screens. He was clean on his last 3 screens. He's moved into transitional housing. And I guess I didn't go any further, Your Honor. I looked at, obviously this court's well aware, the felony sentencing guidelines, and they cut both ways in this case. But what stuck out to me the most, Your Honor, is, to promote the effectiveness of rehabilitation of the offender while using the minimum sanctions the court determines to accomplish those without imposing an unnecessary burden on the state and local government resources. So I guess I boil it down for my simplified brain. Either we can send John to prison and put the burden of the taxes on all the people in the state of Ohio, or what John has done is he's cleaned himself up, he's rectified the addiction, or hopefully that he'll battle, that led him to steal again and again and again and again. Sure, we can send him to prison. He can do 10 months, 12 months, 24 months, come out, damaged goods again. Or this court, which is many guys have succeeded, can put him on a short leash for a period of 2 years, monitoring how he's doing, hopefully keep on the track of staying sober and clean, and we don't have this problem again. And last thing, I'll wrap it up, and I guess I should have thrown it earlier, not to embarrass John. Maybe that's why you don't want to go to prison. You know, while in prison at his last stint, he was assaulted. He was raped. He was sodomized. It's a living hell for John. And it should be if you commit a crime. I'm not saying you shouldn't have a living hell to commit crimes. But what we have here, Judge, and I'll wrap it up, is a guy he's here today presenting well. He's clean. He's articulate. He can be an asset to society, and I think the drug court can give him that vehicle to do that, Your Honor. And I think that's exactly why you established this court, for guys like John Jennings. And that's it, sir.
All right, Mr. Jennings, anything you'd like to say?
I have a lot to say.
Short and sweet.
Yeah. First, I would like to apologize to my stepfather sitting over there. I know that his life hasn't been easy since my mom's death. And I'm truly sorry that I'm not there with him for that. Basically, what I want to say is that I could go to prison and stay there and do the time, but just like Mr. Wagner just said, the environment does not help anyone. And my drug use has been my problem my last 30 years of life. Today, I've never been in treatment before like this. I understand it now. I understand. I understand what life's about. I just know a lot. And you might not think I do, but I think I really have gotten it this time. And I really want to be a part of the drug court for the accountability. I am in transitional housing now. I have a part-time job at Bob Evans in Portsmouth. I'm enrolled at the Post University in the human services field. Yesterday, I just completed my one of my qualifications to work at TCC. TCC is going to give me a job in 3 weeks, pending the outcome of this court date.
You're good. You're good. That's all, sir.
Okay. Well, reviewing this, actually the court has given people with a couple of prison terms, maybe even more, drug court. And we've had some of those folks been successful. One of the things that strikes me here, looking at this record, Mr. Jennings, goes back to 2006, is the absence of any drug offenses. They're all thefts. They're all stealing. There's not a single, the closest thing is a minor misdemeanor possession of marijuana, which is like a traffic ticket. It's like getting 2 points on your driver's license. And it's forgery. I mean, back in 2006, it was forgery and a theft. You were on community control. You went to STAR. Then you violated that. And 2009, you went to prison. You were granted judicial release, which when I look at that, I find that hard to believe because I guess I was still kind of naive and young as a judge. I had only been a judge for about 6 months, but I don't grant judicial release to people anymore that I've given community control and violated it. And one of the reasons is because what happened, you were out less than 3 months and PV again and went back. And I think that's when you were supposed to complete the STAR relapse program in that case. And that was not done. You've got a robbery conviction in Campbell County, theft and misdemeanor in Greenfield, 2019. 2019 here, you had 4 counts of forgery in one count of theft by deception, and I think it was the same kind of scenario, stealing somebody's checkbook or credit card. I can't remember which, can't tell from this. And then also a theft of a motor vehicle, and another forgery, and that was in 2 separate cases, and I believe were different victims. And so I don't see, for somebody to have had a drug problem as long as you say you have had, and to use that as the reason that you're committing these crimes, it's astounding to me that you've never been picked up and charged with possession of a felony possession. Cocaine, fentanyl, heroin, not there. And one thing that does run through this entire criminal history is your dishonesty. And so, quite honestly, I question the legitimacy of your claim that you have a drug problem that's causing this kind of behavior. And furthermore, even if you are, drug court, is not designed to protect, to give people who have been harming people constantly an out. And most of the people who have in drug court, yes, some of them did commit property crimes. They were clearly in the throes of addiction and had been in and out of treatment. I don't see any treatment in here for you ever, until this most recent case, other than STAR. And we went through it once, and completed it. The second time you didn't. And so the court feels that, quite honestly, I just think you're a danger to the community, that whenever you're not incarcerated, you steal. You've shown that consistently for the last 17 years. And so the only thing that I can do to protect the public from you is to keep you incarcerated. And I know that's not going to be long enough to stop you from getting out and committing further crimes in the future, but if you're standing there and you're sincere about what you've done, when you get out of prison, you can go into treatment and you can get back into therapy and continue on your way. And so that'll be your challenge. But it's the order of the court that you be and are hereby sentenced on count 1, we need jail time credit, to a term of 12 months, and on count 4 to a term of 9 months. Those sentences are ordered to be served consecutively. And for one reason, as I just stated, your criminal history shows that it's necessary to protect the public to impose a longer sentence. And so that's one reason. Secondly, you committed this as a part of a ongoing series of misconduct, and the harm that is caused as such at one single prison term doesn't adequately reflect the seriousness of your crime. According to the sheriff, you have 8 days of jail time credit, so you'll be given that credit. Now, upon completion of your prison term, the adult parole authority may place you under post-release control for a period of up to 2 years. They don't have to, but they may. If they do, you'll be supervised under the conditions they set, and if during that period of time they determine that you have failed to comply, they can return you to prison to make you serve an additional period of up to 9 months for any one violation, but there is a maximum of half of your prison term, which will be 10.5 months for all violations. However, if you commit a new felony, then in addition to whatever sentence the judge in the new case can impose upon you, the judge is also authorized to sentence you in this case to an additional period of a year, whatever time's left on that period of post-release control, whichever is greater. And if that occurs, that must be served consecutively as sentence in the new case. You're also ordered to pay restitution to Norman Carmine in the amount of $940, and that's a substantive order as part of the sentence, and it'll be payable through the victim witness escrow account. You'll pay any service fees that are charged for that service. You're also ordered to pay the court costs. If you fail to do that, then the clerk can collect that through various means, including levying on bank accounts, wages, earnings, or other assets you may have. If that doesn't collect it, then upon completion of your prison term, not while you're in prison, but once you get out, the court could permit you to do community service and give you credit for each hour you work in and out of the rate set by the court. Each hour you work to reduce your judgment by that amount until paid in full. All right, is there anything further from counsel?
No, Your Honor.
All right, you're remanded to custody. We'll do Colvin next.
May I approach the bench, sir?
Yes, ma'am. All right, Christopher Colvin,
May I approach, Your Honor?
you may. All right, this is case number 23 CR 92, State of Ohio versus Christopher Todd Colvin. Present for the state is Assistant Prosecutor King. Present for the defendant's attorney Jacob Wagner. You are Christopher Todd Colvin?
Yes, sir.
All right, Mr. Colvin is charged in a 26-count indictment, and we had a pretrial yesterday, and it was indicated that an agreement had been reached in this matter, and so it was set for a plea hearing. The court has received this plea of guilty for Mr. Colvin, which indicates you're going to plead guilty to, looks like counts 1, 2, 3, 4, 5, 7, 8, 9, and 10. So it looks like that's a total of 9 charges. It involves assaults on peace officer, intimidation, handling sexually oriented material involving a minor. This document is 4 pages long. The last page is actually an entry. The last sentence on page 3 reads, "I enter this plea voluntarily," and immediately below that there's a signature that looks to be Christopher T. Colvin. And below that, your attorney's signature. And did you sign this document I'm looking at, Mr. Colvin?
Yes, sir.
When did you sign it?
This morning.
All right, now, before you signed it, did your attorney go over it with you and explain everything to you and answer any questions you had?
Yes, sir.
Did you understand when you signed it that it's an agreement to plead guilty, which means there's not going to be a trial, and the next step will be a sentencing hearing?
Yes, sir.
And do you feel you had enough time to fully consider this matter before making this decision?
Yes, sir.
And are you entering into this agreement voluntarily?
Yes, sir.
All right, now, Mr. King, we do have no identifiable victims in the first 5 counts, or alleged victims. Are any of those individuals or representative present for this hearing?
No, Your Honor, they're not. All victims have been notified, none are present.
And they've all been informed of the nature and purpose of the hearing, the right to be heard?
Yes, sir, Your Honor.
All right. Now, Mr. Colvin, the first sheet of the agreement lists the penalties for these offenses. Counts 1 through 4 are the same charge, assault on a peace officer, under 2903.13a, fourth degree felony. And it states there that the prison term there is possible, the maximum is 18 months, the minimum is 6 on each of those counts. There's a fine available of up to $5,000. Count 5, intimidation, under 2921.03a is a third degree felony, and that possible penalty, and that's not an offense of violence, not a high tier offense?
No, Your Honor.
That is a possible sentence of minimum of 9 up to 36 months in the increments provided by law. It goes from 9 to 12, and then every 6 months up to 36 months, there's a fine available of $10,000. Then counts 7, 8, 9, and 10, the pandering charges are also under 29, pandering sexually oriented matter involving a minor, under 2907.322A5 are all fourth degree felonies, which carry a same penalty as the first 4 counts, 6 to 18 months and a fine of $5,000. Now, in the event that you were sentenced to consecutive sentences on this matter, that comes up to a total of 180 months and a fine of $50,000. Do you understand that?
Yes, sir.
Now, are you facing any felony charges in any other court?
No, sir.
are you currently on community control, probation, parole, or post-release control for a felony?
No, sir.
Right now, under the law, if you're sentenced to prison on these offenses, with regards to counts 7, 8, 9, and 10, those are considered to be sex offenses under the law, and therefore it is mandatory that once you complete any prison term that's been ordered by the judge, that you be put under post-release control supervision for at least 1 year up to a maximum of 3 years under the supervision of the adult parole authority. You'll be supervised by a parole officer on the terms they set. If during that period of time they determine that there's been a violation of those conditions, they have the authority under the law to return you to prison to make you serve an additional period of up to 9 months for any single violation, up to a maximum of half of the prison term for all violations. However, if your violation is a new felony, or if you commit a new felony, I should say, while under post-release control, then in addition to whatever sentence could be imposed by the judge in that new case, that judge would also be authorized to sentence you for committing that offense while under post-release control, in this case, to an additional period of a year, or whatever time is left on that period of post-release control, whichever is greater. And if that occurred, that has to be served consecutively to the sentence in the new case. Do you understand that?
Yes, sir.
And now, under the law, none of these are mandatory prison offenses, and so the court could impose community control, which means, or non-prison, which means probation instead of going to prison. And if that were to occur, you'd be put under supervision of a probation officer for a period of up to 5 years under the terms that are set by the court. If during that period of time probation felt that you were not complying, they would file a written notice of that with the court and give you a copy. There would be a hearing. If the outcome of that hearing was that you'd failed to comply, then at that time the court could revoke your community control and then sentence you to the 180 months and fine you for $50,000. Do you understand that?
Yes, sir.
All right, now we'll review the charges. And counts 1 through 4 are all the same offense, assault on a peace officer. And first count alleges that on or about May 10, 2023 in Highland County, Ohio, you did knowingly cause or attempt to cause physical harm to V1. The designation now, the law requires that people that are alleged victims be identified by a code rather than by their name. So V1 is a designation of the alleged victim. A peace officer as defined in 2935.01 of the revised code while in the performance of his official duties in violation of section 2903.13a. Count 2 alleges the same offense except it identifies the alleged victim as V2. Count 3 alleges the same offense except it identifies the victim as V3. And count 4 alleges the same offense except it identifies the alleged victim as V4. And these are 4 separate individuals alleged to have been the victims of these 4 offenses. Count 5 alleges that on or about May 10, 2023 in Highland County, Ohio, you did knowingly and by force or unlawful threat of harm to the person of V1, V2, V3, and V4, attempted to influence or intimidate or hinder V1, V2, V3, and V4 public servant in the discharge of his or her duties as a public servant, violation of section 21.03. And so that is the intimidation charge, the 3rd degree felony. Count 6 alleges on or about May 10, 2023 in Highland County, Ohio, you did purposely and by force or by unlawful threat of harm to V1, V2, V3, and V4, retaliated against a public servant, V1, V2, V3, and V4, who is involved in a criminal action or proceeding because the public servant discharged his or her duties as a public servant, violation of section 2921.05a. That's a charge of retaliation, which is also a 3rd degree felony, the same as, wait a minute, he's not pleading to that, is he? No, I'm sorry. 6 is not involved.
Yeah, 6 out, 1, 5, 7.
I was just going down the list. All right, so disregard what I just said. The retaliation charge is one of those that's being dismissed, count 6. All right, now, count 7, 8, 9, and 10 are all the same offense. And it alleges, count 7 alleges that it occurred on or about April 15, 2023 in Highland County, Ohio, that you did with knowledge of the character and material performance involved buy, procure, possess, or control obscene material that has a minor as one of its participants in violation of section 2907.322A5. Count 8 alleges the same thing. Count 9 alleges the same thing, and count 10 alleges the same thing. All of those are illegal use, pandering sexually oriented material involving minor. And with those, they don't have identifiable, are these internet downloads, Mr. King?
Your Honor, they're images on an SD card, so they're,
Okay.
yes, they're not identifiable.
All right, all right. All right, and so all of those offenses are fourth-degree felonies, as are counts 1 through 4. So you have 8 fourth-degree felonies with a possible penalty between 6 and 18 months, and you have the intimidation charge, which is a third-degree felony, which has a maximum possible penalty of 36 months and a minimum of 9. And I haven't done the math in my head, but have you guys checked your figures, make sure that the numbers are right?
Multiple times.
Yes.
Okay. All right, well,
And the counts and everything.
all right, because I know one time I didn't check it and there was a mistake. One time I didn't check, it was a mistake. So I'm going to go ahead and trust you guys this time, just so it's on the record that you've done it. All right. Now, Mr. Colvin, do you understand what the charges are in each of those counts, what the state said you did, when, where, and how they allege that you did it?
Yes, sir.
Have you discussed the nature of those charges, the evidence in the case, possible legal issues in the case, the possible defenses you could try to raise at trial, the possible outcomes of a trial with your attorney?
Yes, sir.
Are you satisfied with his advice and competence in this matter?
Yes, sir.
Now, are you under the influence of any types of drugs or alcohol at this time?
No, sir.
Are you taking any prescription drugs?
No, sir.
Has anyone threatened you to make you plead guilty here today?
No, sir.
Now, on page 3, toward the top, there are several sentences, looks like about three plus sentences, printed in bold and underlined that read as follows. And it looks like there's been some changes to some of the counts with ink. So I'm going to read it as it's there with those changes. Defendant shall enter a plea of guilty to counts 1 to 5 and 7 to 10. State will dismiss remaining counts. State and defense jointly recommend 24 months on count 5, consecutive to 12 months each on counts 1 through 4 and 7 through 10 for a total of 10 years. I think it'd actually be 120 months, wouldn't it?
Yes, Your Honor.
Correct, because those are all month sentences. All right. And defendant would be designated as a Tier 2 registered sex offender. And so for the record, the 1 through 5 after counts and 7 through 10 are, well, actually 10 is written in ink, and then on the sentence recommendation it's been changed to 7-10. Now, other than that, well, let me back up. Designation of a Tier 2 sex offender means that you'll be required to register with the sheriff once you're released from custody if you are given a prison term for a period of time, which I'll go over if you end up pleading guilty. I'll explain that to you. But you understand that's going to be an obligation.
Yes, sir.
All right. Now, other than what I just read to you, has anyone promised you anything to get you to plead guilty here today?
No, sir.
Now, under the law, the court's not bound by the sentencing recommendation of the parties. And so if you plead guilty, the court, after considering everything, could decide that you should receive more than that, up to the maximum of 180 months, as opposed to the maximum that's being recommended here of 120. Do you understand that?
Yes, sir.
Okay. Now, Mr. Colvin, do you hold any license or certification from any state governmental agency that regulates any occupation or profession?
No, sir.
All right, now you have certain constitutional rights you must understand before I can accept a plea of guilty from you. First, you have the right to have counsel. Mr. Wagner was appointed to represent you, and I know he's represented you since the bind over because he and the prosecutor have talked with me a couple times. And he wasn't appointed simply to work the case out. He is appointed to represent you, and if you decide you do not want to do this, he will continue to represent you and defend you, including having a trial, if that's what you want. You understand that?
Yes, sir.
Now, under the law, Mr. Colvin, you have a right to have a jury trial in this matter, in which 12 people will be selected from a group of citizens that live in Highland County that are summoned for jury duty on your trial date. After those jurors are selected, the evidence will be presented, and then they would be instructed on the law. And then that jury would have to decide by unanimous verdict, meaning all 12 of them would have to agree on a verdict as to each of the counts. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you can waive in writing, which means to give up, your right to have a jury trial. And in that case, you would have what's called a court or bench trial, meaning that instead of a jury hearing the evidence, the judge would be the one who would hear the evidence, apply the law, and decide whether or not the state proves your guilt. Do you understand that?
Yes, sir.
All right, now, under the Constitution and the law, in this case, Mr. Colvin, you have a right to confront the witnesses against you and to cross-examine them through your attorney. What that means is that the witnesses against you have to come into court and testify in front of you and your attorney, and anyone else may be present. After the prosecutor's done asking questions, your attorney can ask questions. That's called cross-examination. The purpose of that is to try to bring out evidence that would help your side of the case. Do you understand that?
Yes, sir.
Now, under the Constitution, you have a right to use the power of this court, Mr. Colvin, to compel or force witnesses to come in and testify on your behalf, the same as the state. So if you have any witnesses that you are not certain will come to court or can come to court voluntarily, then at your request, a subpoena is issued, which is a court order, that forces those people to come to court, be available to testify if you want them to, even though they don't want to be here. And that's the same way the state's witnesses are required to come to court. You understand that?
Yes, sir.
Now, under the Constitution, you have a privilege against self-incrimination. That means you cannot be forced to give evidence against yourself at any time in this case. No one can ever make you testify. The prosecutor can't, the judge can't. It's your decision. If you decide that you're not testifying, the fact that you did not testify cannot be used against you in any way, at any time, by any person in the case. And in fact, no one's even allowed to talk about it except in one situation. If there's a jury trial, then you don't testify. The judge instructs the jury that because that is your right, they can not consider it for any purpose. Do you understand that?
Yes, sir.
Now, under the law, you are presumed innocent until proven guilty by the state of Ohio on every essential element of these charges, each of them. So what that means is the burden of proof isn't on you to try to prove you're not guilty simply because you've been accused by being indicted. In fact, under the law, you don't have to present any evidence at all in your own defense. You may, but you're not required to. But whether you do or not, the fact is that, or the law is, that the burden of proof will be on the state to prove your guilt by proof beyond a reasonable doubt on every essential element of each of those 9 charges that we have here. And that is the highest burden of proof that's known under the law. Do you understand that?
Yes, sir.
All right, now originally you entered a plea of not guilty. Not guilty plea denied the allegation in the indictment, denied you committed any crime. And that plea invoked or exercised all the rights that I've described for you this afternoon. If you change your plea from not guilty to guilty, that is the complete opposite of the not guilty plea. Guilty plea admits the allegations in the indictment, admits that they're a crime, that you committed that crime. And that plea waives, gives up all the rights that I've described for you previously this afternoon, except your right to have an attorney. Because you always have a right to have an attorney no matter what your plea. Well, with that exception, your plea of guilty waives, gives up your right to a jury or a court trial. It waives, gives up your right to confront witness against you and to cross-examine through your attorney. It waives, gives up your right to use the power of the court to compel or force witnesses to come to court to testify on your behalf, the same as the state. It waives or gives up your privilege against self-incrimination because if you say you're guilty, that's what's used to find you guilty. It waives or gives up your presumption of innocence because if you say you're guilty, then the state doesn't have to prove you're guilty. Now, a plea of guilty subjects you to being sentenced immediately by the court, which is what's likely to happen here if you plead guilty. And it waives, gives up any right to file an appeal you think you could have had up until this point in the case. Now, if you should receive the maximum sentence on any of these charges or under other limited circumstances, you could file an appeal. But it would have to be filed within 30 days of your sentencing entry being filed. Do you understand all of that?
Yes, sir.
And Mr. Colvin, are you a U.S. citizen?
Yes, sir.
Now, do you have any questions about these 9 counts that were talked about and what the penalties are?
No, sir.
You understand them?
Yes, sir.
You have any questions about the plea agreement?
No, sir.
You understand it?
Yes, sir.
You have any questions about the constitutional rights I've explained?
No, sir.
Do you understand those?
Yes, sir.
You have any questions about the plea of guilty, what it means, or what will happen if you enter that plea here today?
No, sir.
You understand?
Yes, sir.
Is there anything you need to speak with Mr. Wagner about before we go any further?
Yes, sir.
Then is it your decision to go forward in accordance with the terms of this plea agreement and plead guilty to counts 1 through 5 and 7 through 10?
Yes, sir.
All right. Then as to the first count, that alleges that on or about May 10, 2023 in Highland County, Ohio, you did knowingly cause or attempt to cause physical harm to V, as in Victor 1, a peace officer as defined in section 2935.01 of the revised code on the performance of his official duties in violation of section 2903.13a, the charge of assault on a peace officer, a fourth-degree felony carrying a possible prison term between 6 and 18 months, and a fine of $5,000. How do you plead?
Guilty.
As to count 2, which alleges the same offense except that the alleged victim is V2, otherwise it's the same language, the same offense, the same penalty. How do you plead?
Guilty.
As to count 3, which alleges the same offense, the same date and time, except that the alleged victim is V3, that otherwise has the same penalty and the same title. How do you plead?
Guilty.
As to count 4, which is the same offense except alleged to have occurred on the same date against alleged victim V4, otherwise the same title and penalty. How do you plead?
Guilty.
As to count 5, which alleges that on or about May 10, 2023 in Highland County, Ohio, that you did knowingly and by force or unlawful threat of harm to the person of V1, V2, V3, and V4, and all those are V as in Victor, attempted to influence or intimidate or hinder V1, V2, V3, and V4, a public servant in the discharge of his or her duties as a public servant in violation of section 2921.03a, the revised code, the charge of intimidation, a third-degree felony carrying a possible prison term between 9 and 36 months, and a fine of $10,000. How do you plead?
Guilty.
As to count 7, that alleges that on or about April 15, 2023 in Highland County, Ohio, you did with knowledge of the character, the material, or performance involved by, procure, possess, or control obscene material that has a minor as one of its participants, a violation of section 2907.322A5, a charge of pandering sexually oriented matter involving a minor in violation, as I said, of 2907.322A, a fourth-degree felony with a possible prison term between 6 and 18 months and a fine of $5,000. How do you plead?
Guilty.
And then count 8 that alleges the same offense in the same language but a different participant, otherwise the same title and penalty. How do you plead?
Guilty.
Count 9, which alleges the same offense except a different alleged victim, same title and penalty, same language. How do you plead?
Guilty.
As to count 10, which is the same offense, the same language, except that it involves a different alleged victim, otherwise the same title and penalty. How do you plead?
Guilty.
All right, thank you. You can be dismissed, or you can be seated. All right, the court finds that on this day in open court, defendants advised of all his constitutional rights, made a no intelligent voluntary waiver of the same pursuant to criminal rule 11. The pleas accepted order filed. Defendant is found guilty of counts 1 through 5 and 7 through 10 as alleged in the indictments and in the counts in the indictment. Counts 6 and 11 through 26 are dismissed. Given the nature of the offenses and the recommendation of the parties, the court is not going to order a pre-sentence report. I'll instead proceed with sentencing forthwith. Mr. King, anything on behalf of the state?
Your Honor, before sentencing, does the court wish to go over the registration
Oh, that's right.
requirements?
That's right. Okay, it's here. I just had it. There it is. Thank you for reminding me of that. All right. Before we proceed with sentencing, Mr. Colvin, I'm required to explain to you the duties that you will have to register as a result of this conviction once you're released from custody. The law provides that this offense in count 7 through 10 require a person to be designated as a Tier 2 sex offender, child victim offender registry. Now what that means is that upon release of, from custody, once you finish serving any term that's imposed, you are required to register in person with the sheriff of the county in which you're going to live within 3 days of coming into that county, or if you're going to be there temporarily for more than 3 days. You're also required to register in person with the sheriff of any county in which you may decide to establish a place of education. If you were going to take some classes, college classes, or vocational training, or anything of that nature, job training, you have to register in that county as well. And then finally, if you are employed and work in a different county other than your resident county, then you would be required to register there if you work in that county for more than 3 days in a row, or you're there more than 14 days in any calendar year working. So that means potentially you would be required to register in as many as 3 counties: where you live, where you are attending a place of education, and where you're employed. If you live in a different state, or work in a different state, or go to a place of education in a different state, you must also register in that state with either the sheriff or whatever public official is charged by law in that state with maintaining sex offender registry information. Now, if you are going to be away from your county of residence and specific location, either from your county or from that residence for more than 7 days on a temporary basis, then you're to notify the sheriff of the county you're living in of where you will be, the address of that, and how long you may be there. So if you're on a vacation, or if you go to stay with a family member or a friend because they're ill, or if you have to go to another place to be hospitalized or in a rehab center or something, you have to give them that information. Now, after, if you change any of your addresses, where you're living, or where you're working, or where your place of employment is, then you're required to notify the current sheriffs, as well as the sheriffs of the other counties in which that would be a change. If you're going to change your address, you must give, or your place of education, you must give at least 20 days advance notice of the change to your the sheriff of the counties in which you're registered, and those sheriffs where you're going to be registered, or going to be. If you don't have a fixed address, you have to give a detailed description of the place, or places you intend to stay, and then at the end of the first business day, once you obtain a fixed address, you must give them that information. With regard to employment, you don't have to give advance notice, because you can be in another county for 3 days consecutively, and then after that you have to register. And if it's more than 14 days in a calendar year, then you have to do that, as I've explained already. You're also required to provide written notice within 3 days of any change in your vehicle information, email address, internet identifier, or telephone numbers that are registered to or used by you, and give it to all those sheriffs in the counties in which you have most recently registered. Also, under federal law, you must report any intention to travel internationally at least 21 days prior. And if you don't do that, that could subject you to a criminal prosecution under both federal and state law. Now, the Tier 2 designation is for a period of 25 years. Once you're released from custody, you have to verify every 180 days. And you must do that in person by going into the office. It's not something that can be done by phone or over the internet. It has to be in person. You cannot do that any earlier than 10 days before your verification date. And again, you do have to do that in person. And if you fail to comply with any of these conditions, then you could be subject to prosecution for a felony under Chapter 2950 of the Revised Code. Now, there's a signature here for offender signature that says, "I acknowledge above the requirements have been explained to me, and I must abide by all the provisions of the Higher Revised Code, Chapter 2950. And it looks like your signature on this line. Did you sign this document just earlier?
Yes, sir.
All right. I'm going to put the date, and that was today?
Yes.
I'm going to put today's date there next to your signature, and then I have to sign it myself. All right, and that's been completed. Now we'll proceed with the matter sentenced. Mr. King, anything from the state?
Only was contained in the plea agreement, Your Honor.
All right, and each of the victims, alleged victims, or now victims, agreed to the disposition being recommended?
Yes, sir, Your Honor.
All right, Mr. Wagner?
Your Honor, we would ask the court to file the recommendation, and if I could just have leave of the court, I think it's just important for my own sake to put on the record. Mr. Coleman was arraigned on July 12th. Within 8 days, we're back in front of this court on a 30-plus year case. I was originally appointed clear back in May 11th, Your Honor. Again, I don't know if the court would get here early. I've been out to see Chris multiple times. I've met with Detective Antonor. I've reviewed the SD cards. So about roughly the past 2 months, I've been working on this case and investigating it. So again, just in case some appellate attorney grabs this down the road, he didn't think I cut a deal in 8 days. And I've been out to see Chris multiple times. A bill of information was proposed. We met with the court, the prosecutor. So again, I put about 2 months of work in this, Your Honor. So I just thank you for letting me put that on the record.
All right. Mr. Colvin, is there anything that you would like to say?
No, sir.
All right. Now, Ben, I'll need to. Don't have it? Okay. All right. Well, Mr. Colvin, these are all serious charges and, involved several people in terms of the first 5 counts and then the different individual juveniles or minors that were in these photographs. But to your credit, you have taken responsibility pretty quickly. And again, I know that Mr. Wagner had been working on your case because he had met with the prosecutor and I on at least twice, if not more, times before today. So, taking that into consideration, the court is going to follow the recommendation of the plea agreement. So it is the judgment order of the court that as to counts 1 through 5 and 7 through 10, that you'd be sentenced to a term of 12 months on each of those. As to count 5, it's ordered that you serve a prison term of 24 months. All of those sentences are ordered to be served consecutively for a total of 120 months. The court will note that this is a stipulated and agreed recommended sentence. The court will also find that the offenses are such that there are multiple victims, and although it was apparently, there were 2 different courses of conduct involving counts 1 through 5 and 7 through 10, and one single prison term would not adequately reflect the seriousness of your conduct, and the history of this case and the criminal history would demonstrate to the court that it's necessary for the protection of the public. And the court feels that the sentence is not disproportionate to the harm caused, since talking about a sentence of 120 months out of a maximum penalty, possible 180 months. Now, upon completion of this prison term, it is mandatory because of the conviction on counts 1 through 7, it should be put under post-release control supervision for a period of at least 1 year. For a period of I've got to go back here because
Your Honor, it counts 7 through 10 that require the mandatory.
7 through 10. And it is a mandatory 5 years because it's a sex offense. And so you will be supervised for that entire period by a parole officer, the term set by the Adult Parole Authority. If the parole authority finds that you have failed to comply, they could return you to prison and make you serve an additional period of up to 9 months for a single violation, up to a maximum of half of the prison term for all violations. If you should commit a new felony under post-release control supervision, then in addition to whatever sentence a judge in the new case can impose upon you, the judge could also sentence you to an additional period of 1 year, whatever time is left on that 5 years of post-release control, whichever is greater, if you commit that offense while under post-release control supervision in this case, and that would have to be served consecutively to the sentence in the new case. You're also ordered to pay the court costs, which judge grant execution's order. If you fail to do that, the clerk can collect that through various means, including levying on bank accounts, wages, earnings, or other assets you may have. If that doesn't collect it, then upon completion of your prison term, not while you're in prison, once you get out, you will be permitted to do community service in this county and be given credit for each hour you work in an hourly rate set by the court. Each hour you work, reduce your judgment by that amount paid until paid in full. There will be no fine imposed. All right, is there anything further from council?
Jail time credit, Your Honor.
Oh, I'm sorry, we didn't get that, but the rest date was May the 10th, was it? I'm sorry, April 15th. All right, so.
No,
it was,
Judge.
It was May the 10th.
The investigation started then, but that's not when he was arrested.
Oh, okay, the count 7 through 8 are April 15th, all right. The rest date at May 10?
Yes, sir.
All right. So that would be 21 days in May, 30 in June, that's 51. Today is July 20, that's 20, so that's 71 days. 71 days of jail time credit. Anything further?
On our behalf, Your Honor.
Your Honor.
All right, you're remanded back to custody, Mr. Coleman. Thank you.
Your Honor, quickly, is the Wise Cup hearing, the Zoom, do we need to go back to the office for that, or are you going to do it here in the courtroom?
You can do it here,
Okay.
since everybody's here. All right, case number 23 CR 60, State of Ohio versus Joanne Sue Shapely. Present for the state is our prosecuting attorney Collins and assistant prosecutor King. Present for the defendant's attorney Danielle Witt. And are you Joanne Sue Shapely?
Yes.
All right, Ms. Shapely has entered a plea of guilty to aggravated possession of methamphetamine, a third-degree felony. The matter was referred to the probation department for a pre-sentence report, and I have received that, and have each of the attorneys received a summary.
State has, Your Honor.
I have, Your Honor.
All right. I've also received a letter from Ms. Sturgill, the drug court coordinator, who has screened her and has determined she meets the clinical criteria for admission into the program, if that is what she would like to do. All right. Anything from the state?
Only was contained in the plea agreement, Your Honor.
Ms. Witt?
Yes, Your Honor. We do ask the court to follow the joint recommendation and place Ms. Shapely on community control and drug court. She's been in FRS since May and has been clean since May, and has a desire to continue that and to be in drug court.
All right. Ms. Shapely, anything you would like to say?
I've never wanted this more than anything to stay clean. I struggled with addiction for a while, and I know the effects that it's affected everybody in my family.
Okay. All right, we can be seated. You do, yeah, ma'am, don't disrupt the court with that again. If you're going to yawn loudly, you leave the room. Don't do it again. All right. Now, Ms. Shapely, you've signed the application for admission into the drug court docket. You've talked to Ms. Sturgill about it, is that correct?
Yes.
And under the law, the court doesn't order people to go into drug court. That has to be their decision. And the reason for that is that if you are put on community control under drug court conditions, they're more strict, more extensive, but there's also much more support than there is in the straight traditional community control. Generally, with community control, we're giving the person an opportunity to prove they are not going to commit any crimes. They're going to stay out of prison. And sometimes, you know, it will involve treatment requirements and so forth. But again, the focus is on them not going to prison. With drug court, the focus is on a person becoming sober and maintaining their sobriety. Like I said, it's much more stringent. There are daily call-ins for drug testing. You know, you could be tested 3 to 5 times a week early, and then it'll taper down, and other things. So you're aware of those responsibilities and the commitments you're making?
Yes.
Is that what you want to do?
Yes.
All right. Well, then the court approves the request of the defendant to be put into the drug court docket, and I've signed an entry to that effect. It's the order of Ms. Shapely that you be put under community control under these conditions. Well, it'll be for a period of 3 years, first of all. And you're required to comply with all of the provisions set forth in the description, program description attachments that you were provided before you signed your application. Now, I'm going to summarize some of those. It won't be all of them, but as a general rule, you have to comply with everything that's in that program description. First of all, you obey all laws of all jurisdictions, conduct yourself in a law-abiding manner at all times, report when and as directed, be truthful to the probation department and all answers you give to them. Keep them informed of your residence, place of employment at all times. You may not change either without prior permission. You shall not leave the state of Ohio unless you have prior written permission. You have to have that with you when you do go out of state. You're not permitted to enter upon the grounds of any correctional facility, nor communicate with or attempt to communicate with anyone who's an inmate in any of those facilities without prior written permission. Because of your conviction, you're not permitted under either federal or state law to purchase, possess, own, use, or have under your control firearms, ammunition, or dangerous ordnance. If you did that or do that in the future, it will, unless you have that disability removed, you could be prosecuted for a felony under both federal and state law. It's also a condition you not have any of those items or any other weapons while you're under community control. You're not permitted to purchase, possess, use, or have under your control any kind of a controlled substance, drug of abuse, CBD oil, kratom, or any variant or analog of any controlled substance or drug of abuse that has effects that are similar to those, or any instrument, device, or thing that may be used to administer those or prepare them for administration, unless you have a valid prescription. And if you do, you must provide a copy of that to the probation department within 24 hours of its receipt. You're not permitted to obtain a medical marijuana card either. Even though the law allows that, it's not permitted. Just like the law allows you to drink generally, but not when you're on community control. You're not permitted to purchase, possess, use, or have under your control any kind of alcoholic beverages normally be present in places where they're sold and being consumed, even if otherwise lawful. You submit to drug testing as provided in the program, which includes a requirement to call in daily to see if you're up for a test, and if you are, then you have to report for the test within a specified period. You're not to associate with anyone who's a co-defendant in this case, or any other person who has in the past or could in the future influence you to commit a criminal offense or violate these conditions, which applies also unless it's proven in writing by your supervising officer. And that includes any family members who may fall in that definition, unless you were living with them at the time of the commission of this offense. After the date of this order, you're not permitted to marry or establish cohabitation in a common law marriage type of relationship with another without written permission. You must report any contact with law enforcement or any arrest, citation, conviction, or other charge of violating the law not later than the next business day after that happens. You must provide them with financial information records so your ability to pay any fees or costs can be reviewed. If you're referred by the probation department or any of your programming treatment team for an evaluation or assessment for any type of treatment or therapy or training, educational programming, anything of that nature, you're to submit to that. And if there's a recommendation that you get that programming, you must enroll in and complete that successfully. You're to pay the court costs to make payment arrangements to do that with the clerk. And as I previously stated, you have to comply with your treatment plan as recommended. Now, and as well as all the other conditions that are in the program description. And by being placed in community control, you're deemed to have consented to a search without a warrant of your person, your residence, vehicles used by you or owned by you, or any other property place where you're found at any time by any officer of the probation department. There will be no fine or deriving suspension imposed. The court costs are also ordered to be paid as a substantive order, which means if you don't pay them according to the payment plan, then in addition to being a violation of the community control, it means that the clerk could collect that through various other means, including levying on bank accounts, wages, earnings, or other assets that you may have. And if that doesn't collect it, then court could order you to do community service and give you credit in this county and give you credit for each hour you worked and an hourly rate set by the court, and each hour you work reduce your judgment by that amount until paid in full. Now, in the event that the probation department feels that you're not complying with this program and the conditions, they will file a written notice that with the court, serve a copy on you. There will be a hearing. you'll be entitled to have an attorney. If the outcome of that hearing is that you have failed to comply, then at that time, the court could revoke your community control and then sentence you to prison for 12 months, fine you $2,500. If that happens, upon completion of that term, it's possible the Adult Parole Authority will put you under post-release control for a period of up to 2 years. They don't have to, but they may. If they do, you'll be supervised on the terms they set, and if they determine that you have failed to comply, they can return you to prison and make you serve an additional period of up to half of your prison term for one or more violations. But if it's been a new felony, then in addition to whatever sentence a judge in that new case could impose upon you, a judge could also sentence you for committing that offense while under post-release control in this case to an additional period of a year, whatever time is left on that period of post-release control, whichever is greater. If that occurs, that must be served consecutively to the sentence in the new case. All right. Now that completes the case. You're no longer under pretrial supervision, but you will need to report down to the probation department immediately to let them know that you're now admitted into drug court. You'll be transferred to the drug court probation officer, and I believe we're having our session tomorrow. I don't know if you're in the morning or afternoon session, but have you been there before to observe? Okay, well, check with Ms. Sturgill or your probation officer, and they'll tell you which session you're supposed to be at. You're in FRS, right?
Yes.
Okay. I think we're generally doing those in the morning, which will be that you need to be here at, I forgot what time. What is that usually? 9? It's usually 10 we start, yeah. We have team meeting at 9:30, and we start the court at about 10 to 10:15, so they tell you to be here at 10. But check with them to make sure. Ms. Sturgill will let you know. All right, thank you. No. Well, is there anything further, counsel?
No, Your Honor.
All right,
Thank you.
All right, Sandy Throckmorton. Case number 23CR83. State of Ohio versus Sandy E. Throckmorton. Present on behalf of the state is Assistant Prosecuting Attorney King. Present on behalf of the defendant is Attorney Danielle Witt. And are you Sandy E. Throckmorton?
Yes, sir.
I'm sorry, Dennis Kirk.
Thank you, Your Honor.
Why we had that? Oh no, I'm looking at looked in the wrong part of my bifocals. I saw Witt instead of Kirk, so sorry about that. Apologize to her when you see her, would you? Thank you. All right. And you are Sandy E. Throckmorton?
Yes, sir.
All right. Ms. Throckmorton is charged with aggravated possession of methamphetamine, a 5th-degree felony. The defendant filed a motion for intervention in lieu of conviction, and I don't see a report here.
There should be. I know that I checked with Mr. Reno just a little bit ago, and he had one in the file.
Yeah, I've misplaced it apparently. I do have the report from ours. So, did you see a summary?
You talking about?
Hey Ben, we have a report on Ms. Throckmorton. Huh? Well, I don't see it. Would you check those other files and see if I might have misplaced? I have the letter, but I don't have a report from the probation department. From the. Did you see Mr. Fulton or Mr. Arjima?
I've seen Mr. Fulton.
There's a PSI because I came up a week or so ago and reviewed it.
I did that.
Well,
with
it's
him.
somewhere else. We'll find out here in a minute, hopefully.
I think it was maybe around July 5th is when they issued that, unless they've updated it.
That's awful early. Usually I get them the day before, or sometimes the morning of. Tell you what, while they're waiting for that, if you would just step back. You're Miss Nelson? I want to go ahead and do her case while we're waiting. It just takes a couple of minutes. Huh? No. You shouldn't have, because you're not council record anymore. It's a restitution hearing is all it is. Yeah, all right. No. All right, this is case number 19 CR 139, State of Ohio versus Natasha Nelson. Mr. King is present on behalf of the state, and you are Natasha Nelson.
Yes.
All right, Ms. Nelson was convicted in this court back on December 20th of 2019. Control, and then on March the 31st, that was continued. There's actually another order on March 16th of 2020. Wait a minute. Yeah. All right. And I believe I sentenced her to terminated the case on April the 12th to serve 60 days, and then terminated her community control unsuccessfully. Okay, there was an order here that we have a hearing on April the 20th on this matter.
And then that hearing was terminated because she was in jail at that time.
Oh, okay. All right, so we continued until today. All right. So, Miss Nelson, you owe $800 in restitution. Now, when did you get out of jail?
The 10th of June.
All right. Are you working?
Actually, I'm supposed to start next week.
Where are you going to be working?
At Crest Star and Courthouse.
At what?
Crest Star and Courthouse.
What is that?
It's like a pizza place. It's like a factory.
All right. You going to be working full-time?
Mm-hmm.
And what are you going to be paid?
I think they said $14.50 maybe.
Okay. All right.
I went and paid today. I paid $20. That's all I had on me. And I set up a payment plan for $25 a month.
For how much?
25.
All right. Well, now, is that with the victim witness or with the clerk?
I went to victim witness. I have the receipt, like downstairs.
No, that's the clerk's office.
No, I went.
Did you talk to her?
It's through
I
victim.
had talked to her today, but not in regards to a payment.
I don't have the receipt.
Well, I think you paid the court costs. There's court costs as well as the restitution.
Yeah, I know. I owe $200 in court costs.
How much?
200 or something like that.
All right.
Like this is the receipt. This is from you guys. It says everything follows in there.
She made a payment to.
Yeah.
Okay, so she talked to somebody else?
Yes, Your Honor.
Oh, okay. All
While
right.
we were up here, the payment must have been made.
All right, gotcha. All right. Well, then the court will order that you pay $25 a month on or before the, well, see, since it's almost the end of the month, we'll say the 15th of each month. That way you'll have 3 weeks or so to get a paycheck. And we may hold your paycheck up. I don't know if they pay you weekly or every 2 weeks until it's paid in full. Now, you're also going to get notices from the court clerk, and so for the $200,
Yeah.
so you ought to stop there and make a payment plan there too.
Okay.
Pay $10 a month or something,
Okay.
because the priority is restitution.
Okay.
All right, so I'll put that order on. That'll be an order of the court, and as long as you comply with that, you won't have to be back here. But if you don't comply, then you're going to end up coming back here. Every time you come back to court, it's going to add to your court costs. So, you know, keep in touch with everybody, let them know what's going on, and if you're going to be a day or two late or something, let them know. If you pay more, the sooner you get it paid off, the sooner this will be off your back.
Okay.
All right, thank you.
Thank you.
All right, Mr. Rockland, you want to come on back? No, we're not. We'll be shortly. All right, we're back on record on State versus Sandy Throckmorton. The PSI file was located in the PSI room, apparently, since it was brought up on July the 5th. It was put back there, and I do have that, and as I recall, I think the reason was because she didn't have her evaluation till like the 10th.
That's correct, she was on a waiting list, and she's
Right,
now been
right.
evaluated.
Okay. All right, and I do have the report from PARS, which indicates that she has been assessed, that they felt that her substance use disorder was a part of her problem, and she has been approved. She's been diagnosed with a stimulant use disorder, moderate, and however, you did test positive for amphetamine and methamphetamine on the day of the assessment. And are you scheduled to start sessions?
I have been in them.
Okay. All right. Well, Ms. Throckmorton, I have a proposed plea of guilty here because what this relates to, as we talked about before, is a motion for intervention in lieu of conviction. And I'm sure your attorneys explained it to you, but the court's required to do that in order to make sure you understand what's going on. Now, you're charged with aggravated possession of methamphetamine, which is a fifth-degree felony, carries a possible prison term between 6 and 12 months, fine of $2,500, and possible license suspension of 6 months to 5 years. Now, if you plead guilty and are found guilty and sentenced, then you would have a felony record. And what that means is, the plea of guilty doesn't mean you committed a felony or you have a felony conviction. It's not a conviction until the case is final. And the case isn't final until the court imposes a sentence. Now, the sentence that's possible for this offense could be 6 to 12 months imprisonment, a fine of up to $2,500, and a license suspension of 6 months to 5 years, or any combination of those. And so if that were to occur, then you would have a felony record. Now, there is a provision under the law that the court utilizes that allows a person who enters a plea of guilty to a charge to have the opportunity, depending upon their circumstances, in this case it appears you meet the criteria because you don't have an extensive record, and it allows that person to plead guilty but not be found guilty. What happens is the plea of guilty goes into the file and it shows you pled guilty, but you've not been sentenced, and you're put into this program. And so, since you haven't been sentenced, you don't have a felony conviction yet. Now, the program requires that you follow a treatment plan, which you are now in a certified program at PARS, and you must follow their treatment plan. And also, the law requires that you abstain from using illegal drugs or alcohol for a period of at least a year. So, you're already you tested positive on the 10th, so hopefully you've been clean for 10 days, but if you test positive, then that's a violation. And if you don't follow your treatment plan, then that's a violation. And then in addition, there are some supervision requirements where you'll have to report to the probation department and be supervised under some conditions. Now, the difference between this program and a regular supervision for a convicted felon is that this is much less severe and extensive. And it gives you the opportunity to go through this program, and if you complete the program, you remain drug and alcohol free for at least a year, and you comply with the provisions of the program, then when the court receives that notice from the prosecutor and the probation department that you've completed your program and you've done everything you're supposed to do, including paying court costs and any programming fees, then the charge is dismissed. And even though you pled guilty, you've never been found guilty, so you are not a convicted felon. And then that also makes you eligible to have your record sealed. And what I do normally is go ahead and set that for a hearing, and unless something happens between the time of the dismissal and the time of the hearing, it'll be granted, and the record will then be sealed. And that means that no one will be able to find your case because it can't be inspected by the public. And any references to it are removed from the law enforcement records as well, with a couple of exceptions, which is like if you were going to apply to where they could check to see if you've had previously been in this program, or if you're applying for a certain type of job, it can still be looked at. But usually it just means like in law enforcement. And the advantage to you is that if you do this and you succeed in this program, then the case is dismissed. That's the advantage. Now, the disadvantage is that if you don't succeed, then you come back to court and you're found guilty, then you will be sentenced, and at that time you will have a felony record. The disadvantage is you don't get to try the case afterwards. You don't get to say, let's try this, if it don't work, we'll have a trial. You either have a trial now or you do this, whichever way you want to do it. And so that's the way the program works. Now, in order for that to happen, the probation department would have to file a written notice with the court and give you a copy. Then we would have a hearing and you would have an attorney at that hearing. If you did not have the funds to hire one, the court would appoint one for you. If the outcome of that hearing was that you had failed to comply, then at that time, the court will find you guilty and then impose sentence. Now, at that time, the sentence could be, as I said, 6 to 12 months in prison, could be a fine of up to $2,500. It could also be a suspension of your driving privileges. Or it could be community control. Community control is means that you're under supervision under more strict terms, as I mentioned, than you would be under this program, and that could be for up to 5 years. And in this case, I give you 2 years. I could give you 5 for intervention, but I usually just do 2, because that's usually enough to show whether that person is going to do it. Now, if you're sentenced to community control, then the same thing applies as it does with the intervention program, is that if there is a alleged violation that the probation department feels you've committed, then they will put you into, or they will file a written notice of that, I should say, with the court. There will be a hearing, and if the outcome of that hearing is that you failed to comply, then at that time the court could then sentence you to prison for 6 to 12 months, fine you $2,500. You understand that?
Yes.
All right. And keep your voice up, please. Keep your voice up. I couldn't hear you.
Oh, yes.
Okay. I saw you say yes, but I couldn't hear you. All right. And we need to make sure you're on the recorder. All right. Now, you understand all those things?
Yes.
Okay. Charge alleges that on or about October 7, 2022 in Highland County, Ohio, you did knowingly obtain, possess, or use a Schedule II controlled substance with methamphetamine, violation of Section 2925.11 of the Revised Code. So that's the charge of aggravated possession with the penalties I've just described. Now, do you understand what it is you've been charged with, what the state said you did, when, where, and how they alleged you did it?
Yes.
You discussed the nature of the charge, the evidence in the case, possible legal issues in the case, and possible offenses you might try to raise in trial with your attorney.
Yes.
And are you satisfied with his advice and competence in this matter?
Yes, sir.
And are you under the influence of any types of drugs or alcohol at this time?
I was, yes.
When?
I tested it this morning.
All right. And are you clear-headed enough now to be able to understand what's going on and give correct answers and understand what I'm saying?
Yes, sir.
Okay. I'll commend you for your honesty. Most people wouldn't admit to that. So I'll give you credit for that. Now, you have certain rights you must understand before I can accept your plea, and that's why we've had this plea agreement that's been prepared. And it's on page 3, and there's at the top of the page, there's a sentence that reads, I enter this plea voluntarily, and I see a signature, Sandy Throckmorton. Do you know when you signed this agreement?
What agreement?
I believe it was a couple weeks ago.
All right.
It was not today.
So when you signed it, did you understand what it was, an agreement to plead guilty in order to be put in the intervention program?
Oh, yes, sir.
Okay. And you still want to do that today?
Yes, sir.
And you're doing this voluntarily?
Yes, sir.
Okay. Now, one thing I didn't tell you is that if you should be sentenced to prison, again, the penalty is possibly 6 to 12 months. Upon completion of that prison term, it is possible the adult parole authority could put you under post-release control for a period of up to 2 years. And if they did, you'd be supervising the terms they set. And if during that period of time they determined that you were not compliant, then they could return you to prison and make you serve an additional period of up to half of your prison term for one or more violations. But if you committed a felony, then in addition to whatever sentence the judge in a new case could impose upon you, the judge can then also sentence you to an additional period of a year, whatever time is left on that period of post-release control, whichever is greater. All right, now, the charge, Ms. Throckmorton, reads that on or about October 7, 2022 in this county, you did knowingly obtain, possess, or use a Schedule II controlled substance with methamphetamine, a violation of Section 2925.11. So that's the charge that I just described. with the penalties I just stated. You understand what it is you've been charged with and what the state said you did, when, where, and how they alleged you did it?
Yes, sir.
And have you discussed the nature of the charge, the evidence in the case, possible legal issues in the case, possible outcomes of a trial with your attorney?
Yes, sir.
And are you satisfied with his advice and competence in this matter?
Yes, sir.
All right. Has anyone promised you anything other than going into the intervention program to get you to plead guilty here today?
No, sir.
All right. Now, you have, let me ask you this. Do you hold a license or certification from any state governmental agency that regulates any trade or occupation or profession?
No, sir.
Okay. You have certain constitutional rights you have to understand before you can do this, because again, this is your last chance to have a trial and to stand upon a not guilty plea. So, you have right to counsel. Mr. Kirk was appointed to represent you, not simply to work the case out, but to provide any defense that could be available to you under the law that you would like him to provide. So if you do not, if you decide you don't want to do this, he will continue to represent you, including a trial, if that's what you want. Do you understand that? Do you understand that?
Yes, sir.
All right. Now, you have a right to have a jury trial in this matter, in which 12 people would be selected from a group of citizens that are summoned for jury duty on your trial date. Let me stop for a second here. Do we have a plea agreement on Mr. Weisskopf?
Yes, Your Honor.
Okay, I'll just make sure you had it here. All right,
Yes.
because he's there. All right. We'll be with you in a minute, Mr. Weisskopf. I'm just finishing up here, case here. All right. Now, you have a right to have a jury trial in this matter, in which 12 people will be selected from a group of citizens that live in Highland County. They're summoned for jury duty on your trial date. After they are selected, the evidence will be presented. They've been instructed on the law, and then they would decide whether or not the state proves your guilt. If you didn't want to have a jury trial, but you didn't want to plead guilty, you can waive in writing, which means to give up your right to have a jury trial. In that case, you would have what's called a court or bench trial. And that means that instead of a jury hearing the evidence, the judge would hear the evidence, apply the law, and decide whether or not the state proved your guilt. Do you understand that?
Yes, sir.
Under the Constitution, you have a right to use the power, or you have a right to confront witnesses against you and to cross-examine them through your attorney. That means that any witnesses against you would have to come into court and testify in public in front of you and your attorney and anyone else who's present. After the prosecutor's done asking questions, your attorney would ask questions. That's called cross-examination. The purpose of that is to try to bring out evidence that helps your side of the case. Do you understand that?
Yes, sir.
Now, under the Constitution, you have a right to use the power of this court to compel or force witnesses to come into court to testify on your behalf, the same as the state. So, if you have witnesses you're not certain are going to come in voluntarily, at your request, the court issues a court order, it's called a subpoena, and that forces those people to come to court to be available to testify if you want them to, even though they don't want to be here, which is the same way the state's witnesses are required to come into court to testify against you. Do you understand that?
Yes, sir.
Now, under the Constitution, you have a right or privilege against self-incrimination, which means that you cannot be forced to give evidence in this matter at any time, including trial. No one can ever make you testify. The prosecutor can't, the judge can't. It's your decision. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person at any time. No one's even allowed to comment about it, except in one situation. That is, if there's a jury trial and you do not testify, the judge instructs the jury that because that's your right, they cannot consider it for any purpose. Do you understand that?
Yes, sir.
Under the Constitution, Mr. Throckmorton, you have a presumption of innocence, which means you're presumed innocent until proven guilty by the state of Ohio on every essential element of this offense. So the burden isn't on you to try to prove you're not guilty. The burden is upon the state to prove that you're guilty. In fact, at trial, you don't have to present any evidence. You may, but you're not required to. But whether you do or not, the burden remains on the state to prove that case against you by proof beyond reasonable doubt, which is the highest burden of proof that's known under the law. Do you understand that?
Yes, sir.
Now, originally you pled not guilty. Not guilty plea denies allegations in the indictment, denies you committed a crime, and exercises and revokes all the rights I've just described. Change your plea from not guilty to guilty, that's the opposite. It omits the allegations in the indictment that there are a crime, that you committed that crime. And that plea waives, gives up all of the rights that I've just described for you today, except the right to have an attorney, because you always have a right to have an attorney no matter what your plea. With that exception, your plea of guilty waives, gives up your right to a jury or court trial, waives, gives up your right to confront witnesses against you in open court, waives, gives up your right to use the power of the court to compel or force witnesses to be in court, testify for you, the same as the state. Waives, gives up your privilege against self-incrimination, because if you say you're guilty, the state's not required to prove you're guilty. It also waives, gives up your presumption of innocence, because if you say you're guilty, the state doesn't have to prove you're guilty. It also waives, gives up any right to file an appeal you think you may have had up until this point in the case. Now, if I sentence you at some point in the maximum, or under the certain circumstances to file an appeal, it would have to be filed within 30 days of your sentence and intervening file. Do you understand all that?
Yes, sir.
And are you a U.S. citizen? Are you a U.S. citizen?
Yes, sir.
All right, do you have any questions about the charge of the possible penalties?
No.
You understand them?
Yes, sir.
Any questions about the intervention in lieu of program and what's going to be required of you?
No.
You understand them?
Yes, I do.
Okay, keep your voice up.
Yes, I do.
You understand the constitutional rights I've explained?
Yes.
You understand what the plea of guilty means and what will happen if you enter that here today?
Yes.
Is there anything you'd like to speak with your attorney about before we go any further?
Any questions?
No.
Okay, just tell him no.
No.
And is it your decision to go ahead and plead guilty in exchange for being put in the intervention program as we just discussed?
Yes, sir.
Stand up.
As for the charge in count 1, it's alleged on or about October 7, 2022 in Highland County, Ohio. You did knowingly obtain, possess, or use a Schedule II controlled substance of methamphetamine in violation of Section 2925.11 of the Revised Code, a 5th-degree felony, carrying a possible prison term between 6 to 12 months and fine of $2,500 for possible license suspension from 6 months to 5 years. How do you plead? How do you plead?
Guilty.
Thank you. Be seated. All right. The court finds that on this day, an open court defendant was advised of all constitutional rights, her constitutional rights, and made a knowing, intelligent, voluntary waiver of those pursuant to Criminal 11. She has pled guilty. The court finds that she has filed a motion for intervention in lieu of conviction. She is in a certified treatment program, is otherwise eligible for community control. She's not a repeat or dangerous offender. She's otherwise eligible for intervention. The court finds her drug use was such that it was a factor that led to the criminal offense with which she's been charged, and that intervention would not demean the seriousness of that offense and would substantially reduce the likelihood of future criminal activity. The court therefore accepts the plea but will not make any finding. Instead, the criminal proceedings are stayed pending a report from the probation department and the prosecutor's office regarding the defendant's progress. She is placed under 2 years of community control under the conditions for this program that have been approved by the court. She must successfully complete her intervention program, including the requirement she abstain from using drugs or alcohol for a period of 1 year, and she should comply with all the terms and conditions set forth in the program the probation department will go over with you that have been approved by the court. Also order to pay the court costs. Now, in any event that you successfully complete this plan, Ms. Throckmorton, then upon receipt of that information, after at least a year, the court will terminate the case, dismiss it, and set the matter for a sealing hearing, and you will not have a criminal record. On the other hand, if you fail to comply with any of these conditions in this order or your treatment plan, then upon written notice of that to you and to the court, there will be a hearing. You'll have an attorney. If the outcome of that hearing is you fail to comply, then at that time you'll be found guilty, and you could be sentenced at that time to a prison term of between 6 to 12 months, fine $2,500, and a license suspension of 6 months to 5 years. All right, is there anything further from counsel?
No, Your Honor.
No, Your Honor.
All right, now, Ms. Throckmorton, you really need to work, and if you continue to test positive, they're probably going to tell you to go to residential treatment, and I would suggest that you follow, well, you're required to follow those recommendations, because if you're using now, and you just used this morning or last night, whenever it was, you know, you're probably not going to last very long on your own. Most people need residential treatment, and so I'm going to guess that that's going to, they're going to monitor that, and if that changes, you're going to end up doing that. So, but you need to make sure that you follow whatever recommendations they say. All right. So you're no longer in pretrial supervision, house arrest, or any of that. You need to report down to the probation office to see probation department so they can transfer you to this program. All right. Thank you. All right, can you hear me, Mr. Weiskup? Okay. All right, this is case number 23 CR 0115, State of Ohio versus Jamie A. Weiskup. Mr. Weiskup is appearing by Zoom. This was set as a Zoom hearing, but we've been in court all afternoon with other cases, and Mr. Wagner is present in the courtroom. Mr. King, on behalf of the state, is present. Mr. Wagner, are you your client okay with going ahead and proceeding in this kind of a blended situation?
We are, sir, or if he wants me to go back into the back jury room, I'll do that too, but yes, I'm fine with it, sir.
All right. Mr. Weisskopf, do you need to talk with your attorney about anything? Because if you do, I can put you I can have him log into the Zoom hearing, and he'll go back in the jury room and close the door and talk to you if you need to. Do you need to do that, do you think? Okay, all right. Well, if anything comes up during the hearing and you want to do that, then I'll have him go back there, and he'll log in with his phone, and just be the two of you talking, and the deputy will step out of the room, okay? Okay. All right. But if anything comes up, okay, just tell me. And then, so with that understanding, are you agreeable to appearing by Zoom from the jail rather than being here in the courtroom in person? All right, thank you. All right, Mr. Weisskopf then is charged along with two co-defendants. Looks like he is charged in counts 9 and 10 with aggravated trafficking and aggravated possession of methamphetamine. I have a proposed plea of guilty form here that indicates you're going to withdraw your not guilty plea and plead guilty, Mr. Weisskopf. I'm going to hold that up to the camera so you can see that. It has the first page of that agreement. You recognize that? Has your name, case number, says you're going to plead guilty to count 8 or 9, I mean, okay? All right, then on page 3, about halfway down the page, the sentence reads, I enter this plea voluntarily, and right below that there's a signature line for defendant. Below that's Mr. Wagner's signature, and is that your signature right there next to my finger under the line that says I enter this plea voluntarily?
Yes, sir.
And when did you sign this agreement, Mr. Weisskopf?
Yes, sir.
Right, and you indicated earlier that you and Mr. Wagner talked about this and went over everything. Did he explain everything in this agreement to you? All right. And do you feel you had enough time to fully consider this matter before making this decision to sign the agreement?
Yes, sir.
You feel you were pressured or rushed in any way?
No.
All right. And did you enter into that agreement voluntarily?
Yes, sir.
And are you still wanting to go forward with this today?
Yes, sir.
All right. The agreement states you're going to plead guilty to count 9, aggravated trafficking methamphetamine under 2925.03A1, a third-degree felony. States you understand the maximum prison term for that could be 36 months. The minimum would be 9, and there's different levels in between. Could be a fine of $10,000. There is a mandatory fine of $5,000, and a possible license suspension of 6 months to 5 years. Now, the law presumes that this type of offense should receive a prison sentence, but it's not required. Do you understand that?
Yes, sir.
Are you currently facing any felony charges in any other jurisdiction, Mr. Weisskopf?
No, sir.
Are you on probation, community control, parole, or post-release control for a felony in this state?
No.
Okay.
No felony probation.
All right. Now, under the law, if you should be convicted of this offense and if you should be sentenced to prison, the law provides that the Adult Parole Authority may, after you complete the prison term imposed by the court, put you under post-release supervision, post-release control supervision for a period of up to 2 years. They don't have to, but they can. If they do, you'll be supervised under the term set by the Adult Parole Authority by by a parole officer. And if during that period of time the APA officer finds that you have failed to comply, then they could return you to prison, even though you served the term set by the court, for an additional period of up to a year or whatever time is left on the post-release control period, whichever is greater. If that occurred, that would have to be served consecutively, the sentence in a new case. Do you understand that?
Yes, sir.
Under the law, I'm not required, as I indicated, to sentence you to prison. I can give you what's called community control or probation, meaning you'd be supervised by a probation officer in a term set by the court for up to 5 years. If during that period of time they determined that you were not in compliance, they would file a written notice alleging that with the court. You would get a copy of it. There would be a hearing. If the outcome of that hearing was that you had failed to comply, then at that time the court would revoke your community control and then sentence you to prison for between 9 and 36 months, fine you $10,000. Do you understand that?
Yes, sir.
All right, now the charge in count 9 alleges that on or about November 1, 2022 in Highland County, Ohio, Donald Earl Elliott and you did knowingly sell or offer to sell methamphetamine, a Schedule II controlled substance, an amount equal to or exceeding bulk amount, but less than 5 times bulk amount. Is that your understanding of the agreement? Do you understand that charge?
Yes.
And you understand what the state said you did, when, where, and how they alleged you did it?
Yes, sir.
And you understand the possible penalties for that offense?
Yes, sir.
Now, have you discussed the charge, the evidence in the case, possible legal issues in the case, and possible defenses you could try to raise at trial, and the possible outcomes of a trial with your attorney?
Yes, sir.
Are you satisfied with his advice and confidence in this matter?
Yes, sir.
Are you under the influence of any types of drugs or alcohol at this time?
Yes, sir.
Has anyone threatened you to get you to plead guilty here today?
Yes, sir.
Now, on page 2, there are several lines printed in bold and ink that read as follows. Defendant shall enter a plea of guilty to count 9. State will dismiss count 10. State and defense jointly recommend community control. Defendant shall pay money back to the task force in the amount of $100. Defendant shall cooperate fully and truthfully against co-defendants and shall cooperate fully with the task force. And then an additional sentence in ink reads, restitution shall be paid joint and several with Donald Elliott. Is that your understanding of the agreement?
Yes, sir.
Anyone promise you anything other than that to get you to plead guilty here today?
Yes, sir.
Now, under the law, Mr. Weisskopf, the matter of sentence is up to the court, not to the parties, and so even though both parties agree you should get community control or probation, once all the information submitted to the court is considered, if the court finds that that's not the appropriate sentence, then you could be sentenced to prison for between 9 and 36 months in increments provided by law, receive license suspension, and a fine. Do you understand that? Now, Mr. Weisskopf, do you hold any license or certification from any state governmental agency that regulates any occupation or profession?
Yes, sir. Just like driver's license.
All right. Now, you have certain constitutional rights you must understand before I can accept your plea. First of all, you have a right to have an attorney. Mr. Wagner was appointed to represent you not simply to work the case out, but to provide any defense could be available to you under the law that you would like him to provide. So, if you decide that you do not want to do this, that you want to fight the case and defend it, he'll continue to represent you, including a trial, if that's what you want. Do you understand that?
Yes, sir.
Right now, under the Constitution, you have a right to have a jury trial in this matter, Mr. Weisskopf, which means that 12 people will be selected from a group of citizens that live in Highland County that are summoned for jury duty on your trial date. After they are selected, the evidence would be presented, they'd be instructed on the law by the judge, and then decide whether or not the state proves your guilt. And their decision would have to be unanimous, meaning all 12 of them would have to agree. If you decided you didn't want to have a jury trial, but you didn't want to plead guilty, you can waive in writing, which means to give up, your right to have a jury trial. And in that case, you would have what's called a court or bench trial, meaning that instead of a jury hearing the evidence, the judge would hear the evidence, the judge would apply the law, and the judge would decide whether or not the state proves your guilt. Do you understand that?
Yes, sir.
Now, under the Constitution, you have a right to confront the witnesses against you in open court and to cross-examine them through your attorney, which means that the witnesses against you have to come into court and testify in front of you, your attorney, and anyone else is present. After the prosecutor's done asking questions, your attorney asks questions. That's called cross-examination. The purpose of that is to bring out evidence that helps your side of the case. Do you understand that?
Yes, sir.
Now, under the Constitution, you have a right to use the power of the court to compel or force witnesses to come into court to testify on your behalf, the same as the state. What that means is that the witnesses against you would have to come into court and testify, or I'm sorry, if you have witnesses that you're not certain will come into court to testify on your behalf willingly, then you will ask the court to issue a subpoena, and the court will do that. And that's a court order that then forces those people to come into court to testify for you, even if they don't want to be here, which is the same way witnesses for the state are compelled to come testify against you. Do you understand that?
Yes, sir.
Right now, under the Constitution, you are presumed innocent until proven guilty by the state of Ohio on every essential element of this offense. So what that means is that you're not required to try to prove, you're presumed innocent until proven guilty by the state of Ohio on every essential element of the offense charged. So what that means is the burden of proof isn't on you to prove that you're not guilty simply because you've been accused. In fact, under the law, you don't have to present any evidence at all in your defense. You may, but you're not required to. But whether you do or not, the burden of proof remains upon the state to prove your guilt on every essential element of the offense charged, which is the highest burden of proof that's known under the law. Do you understand that?
Yes, sir.
Right now, under the law, you have a privilege against self-incrimination, which means you cannot be forced to give evidence in this matter at any time, including trial. No one can ever make you testify. The prosecutor can't, the judge can't, it's up to you. And if you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person at any time. No one's even allowed to comment about it except in one situation. If there's a jury trial and you don't testify, the judge instructs the jury that because it is your right, they cannot consider it for any purpose. Do you understand that?
Yes, sir.
Now, originally you entered a plea not guilty, Mr. Weisskopf, which denied the allegations in the indictment, denied you committed any crime, and exercised or invoked all the rights I've just described. You change that plea from not guilty to guilty. That is the complete opposite of not guilty plea. The guilty plea admits the allegations in the indictment, admits that there are crimes, that you committed that crime. And that plea waives, gives up all the rights that I've just described for you, except the right to have an attorney. You always have the right to have an attorney no matter what you plead. But with that exception, the plea of guilty waives, gives up the right to a jury or court trial. Waives, gives up the right to confront witnesses against you to cross-examine through your attorney. Waives, gives up the right to use the power of the court to compel or force witnesses to come into court to testify for you, the same as the state. It waives, gives up your privilege against self-incrimination because you say you're guilty, that's what you find you guilty. It waives, gives up the presumption of innocence because if you say you're guilty, the state doesn't have to prove you're guilty. It subjects you to being sentenced immediately by the court. And finally, it waives, gives up any right to file an appeal you think you could have had up to this point in the case. Now, if you should ever be sentenced to the maximum sentence or under other limited circumstances, an appeal could be filed, but that would have to be done within 30 days of your sentencing entry being filed. Do you understand all that? And are you a U.S. citizen, Mr. Weisskopf? Do you have any questions about the charge, the possible penalty? You understand them? Have any questions about the plea of guilty, what it means, what will happen if you enter that plea? You understand it? Any questions about the plea agreement itself? You understand it? And again, you understand that the court's not bound by the sentencing recommendation. You have any questions about the constitutional rights I've explained? You understand that?
Yes, sir.
All right, is there anything you need to speak with Mr. Wagner about before we go any further? Then is it your decision to voluntarily plead guilty to count 9 according to the terms of the plea agreement that I just went over? All right, then as to the charge of count 9 that alleges that on or about September, let me back up. November 1, 2022, in Highland County, Ohio, Donald Earl Elliott and you did knowingly sell or offer to sell methamphetamine, Schedule 2 controlled substance, an amount equal to or exceeding bulk amount but less than 5 times bulk amount, in violation of Section 2925.03A1 of the Ohio Revised Code. The charge of aggravated trafficking of methamphetamine, a third-degree felony, carrying potential sentence of between 6 and 12 months imprisonment, a fine of up to $10,000, a mandatory fine of $5,000, and a possible license suspension of 6 months to 5 years. How do you plead? All right, thank you. The court finds that on this day in open court, defendant was advised of all of his constitutional rights, making no intelligent voluntary waiver of the same pursuant to criminal 11. The plea is accepted, order filed. Defendant is found guilty of count 9 as charged, and the indictment count 10 is dismissed. The court will refer this matter to the probation department for a pre-sentence investigation. That'll include an assessment for substance use disorder treatment and or mental health as appropriate. Bond will be continued, and sentencing will be set for August 24 at 1 p.m. Is there anything further from counsel?
No, Your Honor.
No, sir.
All right, you'll be remanded back to custody. The probation department will be in touch with you, Mr. Weisskopf. Thank you. Well, you can talk to your attorney about that. But one of the things, first thing you got to take care of is if you got substance use disorder, it's going to be treatment. But you know, we can talk with him, and he can file a motion for that, and we'll see what the situation is then. So, all right. So, Mr. Wagner heard you. He'll be out to talk to you. All right. Thank you.